over पास ओवर कॉल करिए तो लेकिन नहीं सुन पाएंगे पास फाइल मिल गया आपको कल वैसे
परसों पेज में
For tomorrow your leadership because my senior deputy should be the doctor is appointed. So leadership में
इनका एक मैटर में कुछ पार्ट डिक्टेशन हुआ था नीचे दे रहे थे उसमें लिखिए the counsel for the respondent has submitted that he shall advance his arguments day after tomorrow. Counsel for the appellant has also has no objection to the prayer. So as you wish, post day after tomorrow for the argument of the respondents. पास ओवर नॉट टुडे का चक्कर मत रखिएगा कर लेंगे एक और पास ओवर किसका
Item 6.
Is what do you have to say? Did you find out any such judgment? Did you find out any judgment?
There are two questions that fell from your lordship. First is whether if the tenant's defense is struck off, whether he can cross-examine. On that issue.
There is no problem about it.
Second is whether the evidence can be looked into. Once it is struck off, the evidence can be looked into.
Evidence of the defendant
Defendant can be looked into. So one judgment leadership will find 1988 which are given by Supreme Court.
1988
88 SCC online Patna 266.
1988 SCC online Patna. Yes.
It's not directly on that issue, but if your leadership can take few paragraphs and just these small paragraphs. Para 28.
Yes, 28.
It is therefore logically follows that finding of existence of relationship of landlord-tenant is a sine qua non for passing a decree for eviction against tenant, except in a case as mentioned before the plaintiff on payment of ad valorem profit may obtain a decree for eviction on basis of his general title. Next relevant paragraph would be 34. Paragraph 34 of full bench judgment is taken into consideration. And for our purpose, leadership, para 42 is relevant for our purpose of this case. It therefore logically follows that the defense which are directed to be struck off are only such defenses which he could raise only as tenant and not otherwise. On such touchstones of these considerations, the insertion of the words and further the court shall not allow the tenant to examine landlord's witnesses must be viewed. The very fact that the tenant is not being allowed to cross-examine the landlord's witness on questions of relationship of landlord and tenant, and as such, if the dispute and as such arises a dispute as to whether the plaintiff is landlord or not, and whether the tenant is a tenant of the plaintiff or not, as to whether a defendant is a tenant of the plaintiff or not, the same may have to be decided without there being any material brought on record on part of the defendant tenant.
In such a situation. But it is not clear what will happen if the evidence has already been.
Leadership, if your leadership can keep it next week or some other date, I'll find more details. But on this issue, I've hardly come up with any judgment as to whether once if evidence is already recorded and later defense is stuck off,
What is the impact?
what will be the impact?
You can frame an issue on that. So
But
that
I
is-
must submit to your leadership, this is not there in my substantial question for me, my memo of appeal.
How
But
does that make a difference?
your leadership, yes, court has power under section 100 provision.
Or do you want to file a just formulate it and present it before? You see, 2 points can be formulated. One is whether the evidence of the defendant would have been taken into consideration to come to a finding, because the defense was struck off at a later date. This is one thing which was taken earlier. The second question of law would be whether still, in spite of not reading the evidence of the defendant, whether the judgment can still be sustained. Because that is also an important aspect.
Yes.
Because the judgment may sustain irrespective of the evidence of the defendant. So that we need to see, you just formulate it and then we can just frame those issues and then
I'll do that. Leadership,
anything or whatever is suits you? You want at a later date, you want to examine it more?
Because I've got instruction only yesterday, the execution case is also proceeding. So in addition, we keep it on Monday. By Friday, I will file the supplementary affidavit. I'll go through it.
Essay number 238 of 2023. The learned counsel for the appellant is present. He prays for adjournment to formulate substantial question of law. To formulate proposed substantial question of law over and above whatever has been formulated by the whatever has been proposed by the appellant in the memo. Monday, proposed on Monday.
It should be listed on next coming month.
Monday.
Right.
From Daily News for Panel Solar, item 2, first April 43 of 2012.
Before the respondent, 1 to 10, 1 to 9 initiates his argument. There was some documents that was filed by the state of Jharkhand in a supplementary affidavit, which the respondent 10 to 15 wants to substitute by the certified copies. Therefore, they filed an IA for additional evidence. I am seeking
That is
directions.
already there, IA for
This
additional
is a
evidence.
different one. For these, the documents are already on record by the supplementary affidavit. We just want to replace it by through certified copies. Therefore, we are seeking directions leave to file the
Same documents.
same.
Let them file. No objection in filing, and I'll see to it what response are.
Whatever your IA
What
is
would
there,
be
we
the
will see.
ultimate consequence of all those IAs, we'll separately see.
We'll separately see all your IAs,
Yes.
right? If you want to respond, you can respond.
Yes, I'll also.
If you have anything, you
Because-
just rectify it. देखिए टाइम लेने के लिए ना ये सब ड्रामा नहीं चलेगा यहाँ पर, ठीक है ना? आपको जो करना था आपको एक ही बार में करना था ना. In the midst of the proceeding, after conclusion of your argument, you come up with an IA. Fair है?
I'll respond to it.
Therefore, they are already on.
And who are you? Whom are you
Respondent,
representing?
respondent 10 to 15.
That is, they are the main
These
datas.
are
जिसने अपनी कोई अपील फाइल नहीं की.
हाँ.
इतना डेलिजेंस था तो अपना अपील फाइल करना चाहिए था ना. अपना कोई अपील नहीं फाइल किए, दूसरे के अपील में लगे हुए हैं कि कैसे ये केस एडजर्न होगा. यहाँ एडजर्नमेंट के अलावा सब कुछ होगा. ओके. What do you mean not seeking adjournment? After completing your argument, you file an IA. What do I do to that? I'm absolutely clueless. After completing your argument and without seeking the leave of the court, you file an IA. ये क्या वो है क्या? कि आपको जब मन होगा कल होगा conclusion of argument के बाद एक IA फाइल कर दीजिएगा. कभी जजमेंट के बाद भी IA फाइल कर सकते हैं. आप लोग का तो कोई टाइम टेबल और कोई टाइमलाइन है नहीं, कोई प्रोसीजर नहीं है आप लोग के लाइफ में. है कोई प्रोसीजर? After concluding your argument and without taking the leave of the court, how could you file that IA? Explain. Therefore what?
I was seeking the leave of this honorable court.
No, you have not filed an application seeking leave. You have simply filed the IA. Did you seek any application? No. ये किस तरह का प्रोसीजर? और कब फाइल किए?
Today.
Yes, सब नहीं देखेंगे.
The documents
Please
are
don't.
received on 5th.
बहुत नहीं, आफ्टर जजमेंट में रिसीव कर सकते ना डॉक्यूमेंट. जब आपको डॉक्यूमेंट मिलेगा तब आप फाइल करेंगे. एंड दिस कैन हैपन एनी टाइम. It can happen after disposal of the case also. It can happen after reserving the judgment also. समीर जी, in the midst of the proceeding जो day to day चल रहा है, ये कैसे ले रहे हैं?
नहीं लिए नहीं है. He is seeking leave of your lordship to file.
I don't know. बिना application के हमें लेंगे भी नहीं.
I'll supplement with the
I don't know what you mean. We don't bother about it.
Your lordship may deal with the IS separately post all these
Yes, I will deal
argument.
with, I will deal with each of the arguments.
Absolutely. So my last argument, your lordship would take note, would recollect that the total suit property is approximately 85 acres. Out of that, when my suit was decreed, then the appellant number 1, 2, 3 they have filed. But I have shown that appellant number 1 and 2 have absolutely no locus in the matter. They cannot be said to be aggrieved by the judgment and decree which has been passed in my favor, decreeing the suit of the plaintiff. When the appellant number 3 files, your lordship had asked us to prepare a list where the sale deeds of the appellant, your lordship may take note of only 2 pages, very short, only
other section.
हाँ दे दे उनको भी दे. And they may correct me if factually I am wrong. This is the first list of deeds, list of sale deed executed by Dattas in favor of defendant number 3, Karm Yogi Grainer Samiti. That means this was direct sale deed to appellant number 3 by Dattas. So the total area is by these 4 sale deeds, 5 sale deeds, they are 2.22 acres. And the second one is where the Dattas have transferred some of these properties to some third parties, and then third parties transferred the property to the appellant. The total of that comes to 2.76 acres, and therefore the total of all these, both these types of deeds on which the plaintiff can at best claim its right, it comes only to 4.98 acres. So this prima facie, according to me, they cannot challenge the other portion of the suit property which they have absolutely no sale deed whatsoever. So they cannot be said to be aggrieved persons.
The learned counsel for the respondent plaintiff has provided 2 charts which were relating to the sale deeds brought on record involving third party rights. The list is as follows. इसको quote करना है. The learned counsel for the respondent has submitted that the appellant number 3 would at best claim with regard to 2.22 plus 2.76 equal to 4.98 acres of land and no more.
Not beyond that.
And not beyond. इसको हाँ ठीक है.
Now your lordship,
Yes.
so much has been argued on the temp form is gouged and all those arguments have been made. Your lordship is kindly see the pleading itself. We cannot go beyond pleading. Your lordship may have again made a comparative chart where the statement made by me in the plaint and has been dealt with by the defendants in their written statement. Those comparisons your lordship may kindly take note of. I'll only place the relevant portion.
भैया सबको देते जाइए साथ साथ.
हाँ. first your lordship list of event, only 4-5 paragraphs I have mentioned, that how they intervened. The suit was filed on 22/5/2006. Then written statement was filed by the defendant number 3. It contained para-wise reply to the claim, but in para 3 it had stated that defendant number 1 and 2 have no concern. This I have already argued. Then on 26/6/2009, the Dattas, they intervened. Their intervention was ultimately allowed, and then it was allowed on 17/7/2009, and then they filed a petition on 1/8/2009, and they requested that their intervention application may be treated as their written statement, and which was allowed. Then on 18/8/2009, petition under order 6/17 was filed by defendant 5 to 10 for amendment of written statement for incorporation of para 9 to 17 after para 8 of the adopted written statement. So there was consequently, your lordship would find from the entire written statement of Dattas that there was no para-wise reply whatsoever to the statements made by the plaintiff in their claim. No, despite the amendment sought for and allowed, no para-wise reply was there. Now your lordship may see the comparative chart. I will not waste your lordship's time to other paragraphs. Your lordship may see this second page where loan, mortgage and all those things have been stated by me in my claim. Para 2 have stated what mortgage cases, all those were there. And then column number 3, it has been replied by the Dattas. In column number 3 and 4 are related to Dattas. Second is with regard to defendant number 3.
Intervenor petition is also 3 and 4 is both related to Dattas.
Yes. So intervention
The column
petition.
numbers are first 4 and 5.
4 and 5.
4 and 5.
4 and 5. I stand. Yes. 4 and 5, they are related to Dattas.
Yes.
With regard to whatever statement we have made with regard to loan, mortgage, suit, execution case, what they state in para 2 of intervention petition, that is very important. First, I am reading column number 4. All the mortgage suits, decreed ex parte, as well as execution cases were void and collusive decrees, never acted upon, and notwithstanding those documents, Dattas as well as successors, including the present petitioners, continue to be in possession of the scheduled land as well as other lands of Mauja Ranguni under their khas possession. Then, simultaneously, your lordship may see column 5, para 9 of the amended written statement. The suit is not maintainable and it is barred by law of limitations, specifically Bihar Land Reforms Act. It is also barred under the provisions of CPC. Now your lordship may kindly take note of these lines. The plaintiff and their predecessor in interest have never possessed the suit land at any time, even after symbolic delivery of possession effected in execution case. So there was, according to their implied statement, there was symbolic delivery of possession. So I'll come to this particular paragraph, why this is against the provisions of Indian Evidence Act, section 114E. This statement, I'll come separately. All these previous litigations and judgments have not been fully acted upon, and the predecessor in interest of the answering defendants remained in possession over the suit land mentioned in Schedule A of the plaint along with other land. In fact, the plaintiff and their predecessor in interest never resided in village Ranguni, and therefore they never possessed these lands. Again, over and above, after delivery of possession in the execution cases, the plaintiff and their predecessor in interest never came in actual physical possession of these lands, and they only had right, title, interest in paper only. That means on paper I have right, title, interest very clearly there. Then your lordship may kindly turn to page 7. Exclusive ownership. This statement was made by us, your lordship. I'll just place first. This statement was made by us after two annas. We said in this particular paragraph, thus it would appear that the said Murlidhar Paul and Haribol Paul became the exclusive owners in khas possession of entire 6 annas interest of what Moja recorded in the name of Chandra Mohan Datta, Sachibala and Shambhunath Datta, and continue to possess the same. Now, Datta's statement in extreme right may kindly be seen. It is in para 12 of the amended written statement of defendant number 5 to 10, and then relevant portion is in the next page. Your Lordship. Next page after approximately 10
या
lines.
इसको पूरा पढ़ देंगे.
पूरा पढ़ दें. ठीक.
अच्छा, ये जो दत्तास का जो रिटन स्टेटमेंट फाइल हुआ है, जो ऑर्डर 1 रूल 10 का पिटीशन था, वो हमको मिल नहीं रहा.
ये एक्चुअली क्या हुआ कि because it was treated as miscellaneous petition, therefore it
नहीं,
must
हमको
have been.
रिकॉर्ड में नहीं मिल रहा है.
So can we
Now
on
there is two
affidavit?
records, lordship. One 110 और दूसरा amended. वो हमारे पास में नहीं.
You have it? Both the things. वही इसको थोड़ा फोटोकॉपी करा के लेंगे. ठीक है, वो एक कोर्ट के लिए, बाकी दोनों को भी दे दीजिए.
Or if your lordship so direct we can file it on affidavit.
ये नहीं, affidavit का जरूरत नहीं है.
जो
Stop record.
ऐसे we all are accepting that it was so.
इसको भेज दीजिए ना.
हाँ, it is factually correct.
ऐसा कुछ नहीं है कि इसको एफिडेविट, क्योंकि रिकॉर्ड
नहीं,
में
नहीं,
चीज है तो
मतलब
एफिडेविट का
because it is not there on
The person
record.
who is
yes.
filed-
नहीं, it must be there on record, लेकिन ना
ठीक।
लोकेट नहीं हो रहा.
ठीक।
मतलब एक होता है कि सीक्वेंस में उतना अच्छे से रिकॉर्ड सेट करके नहीं
ठीक,
है.
ठीक.
And it is not in dispute, this was filed. ऐसा तो कोई dispute
नहीं, that has come also.
ठीक, चलिए पढ़िए तो इसको.
Yeah. Para 12 of amended written statement of defendant number 5 to 10. Thus, there are several keywords in the name of different persons of Moja Ramuni. Some of the keywords are Ijmal keywords and some of the keywords are individual keywords. The plaintiffs have alleged that they purchased some of the keywords from the predecessor in interest. All the answering defendants in auction purchase, and they have claimed that they have purchased 6 annas of share out of total 16 annas share of village Ranguni measuring about 415.47 acres, but they never got their alleged share partitioned with the other khewardars, and therefore they could not be stated to be in joint possession to the extent of 6 annas share with the other khewardars. Not only that, after purchasing the kheward, the plaintiff and their predecessor in
एक
interest.
सेकंड होल्ड करिए. Out of 16 anna, 6 anna was sold. They say that it was never partitioned. Right? So it is, since it was never partitioned, it was not possible to earn.
Yes. I'll answer to whatever vagueness is there. I'll show subsequent paragraph. I'll show. Therefore, I am placing I'll meet your lordship's query.
You just keep it in
I'll-
mind,
I'll-
because
I'll-
this is something which is
Why?
haunting.
I'll come to it. Now let us assume, your lordship may kindly pause here. If I am able to establish from subsequent event and the moment the state, there was a proceeding under section 5, 6 and 7 where the specific properties were found to be in my possession, and the state makes an inquiry under 5, 6 and 7 and issues an inform, opens a jamabandi with regard to all these things, then entire vagueness goes away. So because it culminated into a specific property. So therefore, a thing which has subsequently happened, all these vagueness, it was absolutely irrelevant. I'll come to that also, because I'll show it from the auction sales also. But I'll also show from the proceedings under 5, 6 and 7.
Did Dattas have property over and above this?
No, because
They
6
had only
annas,
6 annas.
6 annas interest was
So
there.
whatever was their interest was
Yes,
there.
absolutely. This is what I'll show.
So therefore, Dattas might not have any locus to challenge this,
Absolutely.
because
This
their entire share was sold.
I'll Your Lordship, one thing, I must bring it, yesterday I saw the judgment, which has ultimately been set aside. Now in that portion, Exhibit C is a document which the defendant number 3 had brought into record, which was Exhibit Title Suit of 2003. Every one of us has stated about that. They have also brought plain written statement, and ultimately it was compromised. No one has brought the compromise petition. But it is there in the order passed by this honorable court in earlier round of proceeding. It appears that it was not properly marked, and therefore it is not, we could not find it before you. That very clearly the Dattas admit their entire auction sale, entire title with regard to those properties the Pauls have acquired right title interest, and what they said, the compromise was that the Pauls would be leaving us 76 decimals for our residential purpose. This was the compromise. But in that compromise, they admitted everything, that we have acquired all the right title interest on the basis of auctions. So
that particular compromise was in relation to which property?
In relation to not this property, but a separate property outside 85 acres, because the total property 6 annas of 415 would approximately come to 112 acres. Now, Your Lordship, we have the facts would go to show that there were altogether 6 Jamabandis which were opened. One was Haribol Paul, whose property is not involved here. So all these properties belong to are 85 acres, and 85 acres, this is not included in that. We have compared. But in that
But the genesis is the same.
yes, absolutely.
There also
admit-
auction was involved.
because because that is a property involved in the auction. They say that all the title of the Pauls
Those documents were never exhibited.
that compromise decree is not exhibited. Plaint, written plaint and leader commissioner and order sheet. But this compromise was done after the filing of the first appeal. It was a subsequent. That means during the pendency of first appeal in 2016, this compromise was made.
But that has come on record that there was a compromise.
It is there in the, I said that, but it is not marked. I've prepared, I'll file that, because I was under the impression that it is already marked, therefore I'm not required, I'll be placing that itself. But that is not exhibit. Now, Your Lordship, may kindly allow me to read further in page 8. The keyword, previous page itself, Your Lordship, out of where 415 acres, but they never got their LS share partition with the other Kevardars. Therefore, they could not be stated to be in joint possession to the extent of 6 annas share with the other Kevardars. Not only that, after purchasing the Kevard, the plaintiff and their predecessor in interest never got their names mutated in the Shiresta of superior landlord, and they have never realized rent from the Rayats have been Rayati Khatyans and the Kevard allegedly purchased by them. Thus, even if the purchasing of the Kevard in auction sale, plaintiffs and their predecessor in interest never exercised any act of tenure. This is important. Thus, even if purchasing the Kevards in auction sale, plaintiff and their predecessor in interest never exercised any act of tenure. On the contrary, predecessor in interest of the answering defendant remained in possession of the lands, and they exercised all the acts of tenure holder even after the auction sale of the Kevard. Shall I read the entire statement or only the relevant portion?
Only the relevant portion.
Yes. Then Your Lordship may kindly turn to the most important paragraph, that is page 9, rent assessment case. This would settle the entire issue. Rent assessment and issuance of M forms. We have stated in our para 9, on the vesting of intermediary interest under Bihar Land Reforms Act 1950, on 1/1/1956, the owners filed returns as per provisions of the said Act before the compensation officer Bagmara constituted under the Act, and after due inquiry in respect of the khas possessed land, rent were assessed under section 5, 6 and 7 of the Act, and M forms were issued in the names of the plaintiffs and their predecessor in interest as follows: Ambika Bala Paul, This case number is 387 so Latika Paula Paul, Satnarayan Paul, Ravindra Kumar Paul, Nirmal Kumar Paul, and Haribol Paul. But Haribol Paul's property is not here in litigation. Then your Lordship may see there.
These documents were all exhibited and which were
Yes,
not exhibited?
yes, yes.
All these.
Yes, there. Initially 3 were there before the trial court,
Yes.
and the 2 others have been produced by way of
Additional
order
evidence.
41 to 27.
Okay. Which all were there?
But one mistake we had committed, that the 4th M form was of Haribol Paul, whose property was not there. Therefore, we could not have.
So you are left with 1, 2, 3, 4, 5. Which all were exhibited and which were not exhibited?
That
Okay.
I'll take. If we have filed for additional evidence that apart from that other 3 were exhibited. So I'm sure. In the meantime,
ये दोनों एडिशनल
Your Lordship, Ambika Pala Paul, Latika Pala Paul, and Nirmal Kumar Paul, these were filed before the trial court. And additional evidence we have brought is Satnarayan Paul and Ravindra Kumar. Your Lordship may kindly see each of the written statement, whatever replies there. Para 17, this is reply of appellant number 3. The contents of para 9 and 10 of the plaint are emphatically denied being wrong and incorrect by misrepresenting the true and correct fact. The plaintiffs and their predecessor in interest, in collusion with the then revenue staff, got incorporated their names in M forms as detailed in para 9 of the claim. The fact, however, remained that despite the incorporation of the names as aforesaid, the plaintiffs had no connection or relation to any nature whatsoever with any portion of the land as detailed in Schedule A of the plaint. On attaining knowledge that the plaintiffs and their predecessor have fraudulently, by misrepresentation and in collusion with the revenue staff, got their names incorporated, despite the fact that they were never in possession nor had any concern whatsoever with the land detailed in Schedule A of the claim. The defendants and their predecessor have filed application for fixation of rent in respect of the land detailed in Schedule A of the claim under section 5, 6 and 7 of the Bihar Land Reforms Act 1950. These applications were registered as rent fixation case number so and so 8182 and 2 of 8182. Can I pause here? What? Yes. So here your Lordship may kindly take note of the fact that I had placed the land compensation which was paid on the last occasion. I had read out that portion of the where while paying compensation or fixing compensation in the year 1962-63, in that proceeding, Dattas had objected and we were claiming ourselves to be ex-intermediary jamindars, and then we were claiming that compensation must be paid to us. In that proceeding, when it happened immediately after 1956, then they in 1981-82, they for the first time seek fixation of rent in there, despite knowing that in 1956, after enforcement of BLR Act, we are claiming ourselves to be the ex-jamindars. Then also they filed application in 1981-82. Absolutely no document whatsoever in the meantime.
So there, they filed a case for fixation of rent under BLR Act.
Before circle officer. And that is the reason that circle officer fixes and then he opens Jamabandi. That matter ultimately reached High Court and then DC was asked to hear
So
the
you want
matter.
to say that there was already a fixation of rent
In our favor.
in your favor
And
at
what
the
the
time of
circle
fixation
officer
of
did,
compensation.
he cancelled a Jamabandi, all these Jamabandis which were already opened in 56, 57, and then he creates a fresh Jamabandi in their favor. Then after we came to know in 2000 approximately, then we started filing then the matter reached
These
the
applications were filed before the circle officer.
circle officer. And circle officer cancelled the Jamabandi and then opened Jamabandi in their favor
Your petitions were taken up by whom?
by fixation of
Compensation?
that order is not there. The only Form M is there. Form M is there and order sheets are not there, case number is there. So ultimately what happened, that deputy commissioner taking note of two things and why I am so placing time and again the order passed by deputy commissioner, it shows he is the collector of the district, it shows the correct and true state of affairs with regard to the revenues entries. And what the entry shows, that what he did, he took note of the fact that the orders, the opening of Jamabandi by circle officer was absolutely illegal and cancellation of Jamabandi of calls was absolutely illegal, and therefore what he did was in 2009, he cancelled set aside the order passed by the circle officer and restored the Jamabandi of the calls. This is the ultimate consequence. Then appellate number 3 hearing, they challenged that order before in writ petition and that was ultimately withdrawn, which I had already placed, it was withdrawn before your lordship. We had also filed, I'll openly we had also filed because the deputy commissioner, he had taken out 3 plots from our Jamabandi. Although he mentioned that the M form it was there, but in M form it was wrongly opened in. This was his plea, but we filed and then we withdrew. So as on date, the order passed by the deputy commissioner is absolutely final as regards the entries in Jamabandi is concerned, and he also takes note of all the M forms. So I'll come to that. Your lordship may kindly see, therefore, by referring to their statement, what I wanted to show was, here your lordship may take note of the fact that here the case of all the argument was as if it was the M forms are absolutely forged. That forged means it never existed and we have created some document. But here the fact, the pleading shows that it was there in connivance with the then revenue staffs, we were able to get M forms and get the rent fixed, all these arguments, all these
But
things.
the fact that something had happened
Yes,
much
and that is
earlier
not challenged.
is not in dispute.
That has to be challenged by way of filing an appeal under Section 8. And therefore, rightly, wrongly, let us assume that a wrong order of rent fixation was done in our name, but by implied admission in the written statement, rent was fixed in our name in 1956-57 with all these cases which have been mentioned. So once a rent fixation was done, then it was required to be challenged. No, then what they did, they challenged it in the year 1981-82, getting my Jamabandi cancelled.
Before an authority who was not competent to hear it.
Yes, exactly. And that was the reason for Deputy Commissioner, he takes note of that circular and then he passes an order that he was absolutely incompetent.
So there are two kind of pleadings in connection with certain fraud. There is no doubt that the fraud would vitiate everything.
Yes, absolutely.
But at the same time, the fraud could be, the allegation of fraud could be a mixed question of intent, which may be required to be. When they say that it is the fact that M form was issued according to you, at
Yes,
best,
yes.
trying to figure out what you want.
Yes.
if they say that it was issued in connivance, therefore issuance is not in dispute.
Yes, exactly that. So issuance is not in dispute, and rent fixation is not in dispute.
So it is
So
not
if-
something which out of the blue something has been created later.
exactly. This is my argument. So once it was fixed, rightly or wrongly, it was required to be challenged before the appellate authority and in terms of Section 8 and of the BRR Act. So once that was not done, it was final and binding. And your Lordship, Patna High Court judgment, there are 3 judgments which very clearly say that they are judicial in nature, and therefore they attain finality if the orders are not challenged. So that I'll place here. Then your Lordship may kindly see the same paragraph which I was reading in page 11, first 3 lines. These applications were
They
registered.
would come up with a plea that when a document was fraudulently obtained, then under such circumstances the same need not be challenged, and therefore their application under in the year 1981-82 was right here.
Yes.
This is the
This is, but your Lordship, here as your Lordship noted, that they themselves say that something was done.
issuance was not.
It was, yes, and creation of Jamabandi was not. Because the whole Jamabandi itself mentioned the case number. When the Form M is issued, then the same, on the basis of same same Form M, Jamabandi, it is entered in register. And then state collects rent for
That is the genesis. That is the genesis.
Yes.
It is not the case that subsequently it was interpolated.
Yes.
It was
That
entered
is not their
into.
case.
That is not there.
Now here they are arguing that it is forged, and some local record keeper, he has given a note that it is missing. There is no such M form. Can a simple letter by a record keeper, override the order passed by Deputy Commissioner taking note of that all those M forms and rent fixation cases and holding that the Jamabandis were rightly created pursuant to the M forms?
That's right. Okay.
Page 11 here. These applications were registered as rent fixation case number 1 of 3 8182, 2 of 8182. In these proceedings, fact, hearing both the parties, it was found that the defendant and their predecessor have been coming uninterrupted continuous possession of the entire land detailed in Schedule A of the plaint. The present plaintiff, as is made in para 9 of the plaint, has no basis, and there is no entry in the register with regard to rent roll having been prepared. It was also held that the plaintiff and their predecessor were at no point of time in possession of these land. As per these orders, again this is important, as per these orders, rent was directed to be fixed in the names of the defendant and their predecessor in interest, pursuant to which fresh M-form were prepared and trokas were also created in their names. All this in 1981. The orders passed by the competent authority in presence of the plaintiff and their predecessor in interest have attained finality in view of the fact that these orders were never challenged by the plaintiff and predecessor in interest before any appellate, tribunal or any other authority or court. It shall not be out of place to mention here that the defendants have since then been paying rent to the state government. Since then would mean that 8180. It shall also be pertinent to mention here that at no point of time rent was ever received by the state government from the plaintiff and their predecessor in interest pursuant to issuance of M form in the year 1961-62. Here again, Your Lordship may kindly mark these words. It says, it shall also be pertinent to mention here that at no point of time rent was ever received by the state government from the plaintiff and their predecessors in interest pursuant to the issuance of M form in 1962-63. So, issuance of M form is not disputed, absolutely not disputed. Impliedly admitted that rent form M was issued in 1961-62. In the light of facts and circumstances mentioned here in above, it is apparent that the plaintiff were guilty of suppressive, very suggestive falsity, and as such on this score alone, the very initial say the suit deserves to be dismissed. Then Your Lordship may kindly again come to the written statement of the Aptas, which is in 4th and 5th column of the same, because their statement is more important than the other. I am reading the 4th column. Para 4 of the intervention. It is true that the cause in connivance, here Your Lordship, it is true that the cause in connivance with the revenue department managed to get the rent assessed and form issued in respect of Schedule A. Absolutely conclusive admission. It is true that the cause in connivance with the revenue department managed to get rent assessed and form issued in respect of Schedule A land on the basis of those collusive and some decrees taking advantage of fortuitous circumstances. So what was there? The basis of Form M was those decrees and execution cases, and Form M was impliedly issued. Very clear admission. Then para 5 of the intervention.
Why do you say impliedly issue?
Yes, I'll read out once again. It is true that the cause in connivance with revenue department managed to get rent assessed.
Yes. Impliedly thodi hua.
No, impliedly
It was issued.
issued.
Their case was wrongly issued.
Yeah, their
Maybe
case is wrongly
connivance,
issued. Yes.
Maybe whatever be
Yes,
the
yes,
reason.
yes, yes.
But it is not their case that it was never issued.
Yes. Now they say that it was never issued. That is the
That
point
is not
which I am
their
trying
case.
to show.
Yes.
That is the point which I am trying.
It is one thing to say that it was never issued and something has been created and
Yes.
implanted.
So
It is another thing to say that something was wrongly issued, fraudulently
yes,
issued,
yes.
or whatever be the reason.
Exactly. So here issuance is not in dispute. This is what I am. Para 5 of intervention petition. Later on, that means after the M forms were issued, then they say later on, Dattas too applied for assessment of rent under section 5, 6 and 7 of BLR Act, registered as rent assessment case number 8182 and 8182. In those proceedings, the calls too were impleaded and as parties, and after inquiry it was held that the rent were assessed wrongly, and M forms were wrongly issued in the favor of calls, and it was Dattas in whose favor the rent in respect of Schedule A land were assessed by issuance of M. Then, para 6. Even since the rent in respect of Schedule A are being collected from Dattas and their successor, including the present petitioners, the names of Dattas have been duly entered in Thokas or registered, and since 1980, the rent have not been collected from calls, including the present plaintiffs. So they say that after 1980, the rent is not being collected from calls, but it is being collected. It is the Dattas who are paying rent. That means impliedly by 81-82, when their rent assessment was made, then this was opened in their name and rent was collected from them. Then, para 7 of the intervention. Aforesaid vital fact issuance relating to issuance of M form and collection of rent from Dattas, including the present petitioners on and from 1983, have been conveniently suppressed by the plaintiffs so as to ensure that they are not compelled to make Dattas, that is present petitioners, as party to the suit. And then they also say in para 10, Your Lordship, it has also been suppressed by the plaintiff that they immediately before filing of the suit, the present plaintiff filed a revenue case being miscellaneous case number 5 of 2004-2005 before the additional collector Dhanbad. Here this is the case, same case which was later on heard by the Deputy Commissioner as 5 of 2008. Again, the present petitioners in respect of the Schedule A land.
What
See,
happened to this case ultimately?
ultimately, the order of fixation of rent in 81-82 was set aside by Deputy Commissioner. So that order would be very relevant. I may be allowed to read the entire order of the Deputy Commissioner because very clear it would be, because he has dealt with in detail.
This is exhibit number.
Exhibit number 7, and both sides have filed. They have also.
This exhibit 7 has been placed.
Yes, we have placed.
They are placed now.
Both participants, they will also.
Wherein
Exhibit
it was
7.
observed that a suit is to be filed. In that
Many
case
things are there
itself, it was
also. That-
observed that a suit is to be filed.
No, I'll come to that. I'll come. Can I skip few paragraphs here?
Yes.
Here they mention miscellaneous case 4 of 2004-5 before the additional collector. Again, the present petitioners in respect of the Schedule A land seeking cancellation of Jamabandis of Dattas, including the present petitioners in respect of Schedule A land on the ground that the rent had been wrongly assessed and M form had been wrongly been issued in favor of Dattas in early 1980s. From the revenue case, it is apparent that the present plaintiff admitted that Datta's status of occupancy raya was recognized by the state in 1983 pursuant to the rent assessment case number so and so, and the name of Dattas had been showing in Jamabandi since 1980. It is a fact now here. It is a fact that the miscellaneous case number 545 of 2 was finally heard and decided by the learned Deputy Commissioner Dhanbad, and by an order, interim order dated 10/2/2009, learned Deputy Commissioner held that the M forms issued in favor of Dattas by Circle Officer Bagmara, who did not have the jurisdiction to pass such order, but in the same order it was held that the M form issued in favor of Pauls were also alleged, something there. Then your Lordship, para 12 of the
Let us
same.
understand what is their objection with regard to form.
Yes.
There are two ways to look at it. One is if we look at the form N, and then on the face of it, it is found to be correct, but according to them, it has been fraudulent.
It has been fraudulent.
Right? That is their case. They have not raised any plea that otherwise also, even if the M form is taken at face value to be correct, the plaintiff do not have this. That is not their argument.
No, not.
Their argument is that M form is fraudulent and therefore it could not have been taken into consideration, and M form became the sole basis for the learned trial court to decree the suit, and out of 5 only 3 was exhibited. In spite of that, the entire suit was dismissed.
Yes. This is there. So my argument would be, let us for the moment, Your Lordship, may ignore for all these exhibits, whatever M form is there, whatever exhibit is there, Your Lordship may ignore it. Then what would be the consequence? Now I have a document which prior to vesting it shows that we had purchased 6 anna's interest. Specific details of property is also not there, let us say. Now after vesting what happened? Ultimately Your Lordship we have to, the initial date itself I have said that we have to connect the dots. So my case is that 2 anna, ultimately the entire interest of the Dattas was auction sold and we were put in possession. And whenever there would be a delivery of possession, it would not be of something which is absolutely vague. It has to be a certain property over which I would be put in possession. So I cannot be put in possession over undivided share of 6 annas over the 16 annas. I cannot be. That cannot be execution. Therefore, Your Lordship would take note from when the partition suit is there, preliminary decree is drawn, then final decree takes place, identifying the specific property and then execution takes place. But here, since the property was identifiable, Therefore, the execution, delivery of possession took place. So here is one aspect.
No, how do you say that the property was identified? The reason is that you had only 6 ANA share out of
Yes,
16.
because that 6 ANAs, Khewat, what is Khewat? Khewat mentions specific khatas.
There are
and
two ways
khatas-
to look at it. There
Yes.
is one is the right to collection of rent.
Yes,
When we see it from that perspective, then under such circumstances, if there is 100 rupees collection, then 6 ANAs would be whatever be the ratio out of it. So there is no problem in earmarking your share. But when it comes to 6 ANA share with respect to the properties which you held in your individual capacity and not in terms of any kind of tenancy or any kind of arrangement, then under such circumstances, how do you earmark as to which particular portion of the property fell in your share?
because there were Khewats. Khewat, very specifically, the Khewats contained khata numbers, and those khata numbers had specific plots. So Khewat was of the Jamindar. So if it was of the Jamindar, it mentioned that this Khewat number has these khata numbers within it, and then therefore that was identifiable property.
That was identified
Yes, yes.
out of let's see one khewat, right? Let us see that there was one khewat which consisted of 16 आना, 16 आना होगा तब एक khewat का पूरा complete होगा, 16 आना of that khewat.
नहीं, वैसे नहीं।
If we see 16 आना of that khewat, then the ratio of the khewat is complete. The entire khewat is covered. If we say 16 आना, if we say 8 आना, it would amount to 50% of that khewat. If we say 6 आना, it will be accordingly decided. Right? But the point is, when they talk about 6 आना interest in the entire property of zamindari, therefore, under such circumstances, which property fell in your share? How can that be?
Because it was again, it was specific Khewat numbers were given that this Jamindar has these Khewats in his name, and therefore that the total of those Khewats was ultimately 600. The total of all those Khewats, which was in the name of Dattas. And as your Lordship had mentioned, that those Khewat would again have specific khata numbers. So total 415 acres must have been there. But then the specific, because the specific Khewats mentioned that these were in the name of 2 Anas was Khewat was there, and then the total was.
That is why my specific query was as to whether Dattas had any interest over and above 600.
No, because your Lordship,
Whatever be their interest.
time and again this finding is there, so that would also come as to what would be the effect of those orders by which the either during the rent compensation being paid to the ex-intermediaries with regard to their vesting of their.
Please understand, this is something very lovely. Suppose this room is there. You have 6 ANA interest in this room. So it constitutes a percentage of the entire room. That percentage,
Absolutely.
right corner or left corner is not declared.
Absolutely.
Right? You have some percentage. Let us take it 25%. 4 ANA.
ठीक,
Okay, 25% of this room is your property.
ठीक.
If your 25, if your entire share of 25%, that is 4 ANA, is sold, right? Then you are completely out of the property, irrespective of the fact as to which corner of the property you were in.
Yes, I do.
That is why I want to know, was that the case of the Dattas, that they had property over and above 6 ANAs?
No, because this is finding also. Your Lordship, I had read on that day,
If a portion,
they had nothing left. This is the finding. They had nothing left with them. This was the finding. What would be the impact of that finding in when the compensation was being paid to us instead of them? They objected, and then also their objection was rejected, holding very specifically that they had nothing left in village Rangoli. So nothing left means, as your Lordship pointed out, that
Whatever they
yes,
had,
yes,
in whatever form they had,
yes,
maybe
exactly,
undivided or
exactly,
whatever.
exactly. I do get your Lordship. Now to put
This
it in
they
a
will have
different.
to contribute
Here-
as to whether the fact stands
here-
as it is.
No, it is not there. They do not say that we have over and above 6 annas of interest there or other land. They are only taking one line of our plain where we have said that apart from this one line is
Other
there,
lands.
other lands. That is,
But that is absolutely vague. Be it
Vague.
on your part or be it on their
and
part.
they have not brought. And your Lordship, the evidences are that they have nothing surviving, nothing left. Now here, only to clarify. Now, as your Lordship pointed out that whatever interest they had, they it is not their case that over and above this 6 anna they had other interest also or other properties also. This is not there. And their entire 6 anna interest was transferred. This is one. Now here, as your Lordship pointed out in this room, that 25% of this room is there belonging to me. So, but here is a case where the keywords are there which specifically mention the khata number. Then firstly the properties, that means total keyword, the identifiable properties are taken out, that this is specific portion of the room, and this collectively comes to 25%. Here this is
From
the
where
case.
do you get
This
it?
is the
From where
reverse
do you
case.
get this?
Because the keyword number specifically, that is the identification of the property. Because the keyword mentions the
It was
properties.
not a percentage of that keyword
No,
number,
no, no, no.
but
Not
rather
percentage.
those keywords
No, no, yes, yes.
themselves constituted
Yes,
6%.
yes, yes,
6
exactly, exactly. Those keywords were in name of three dattas, and therefore the properties when they were transferred, and those mentioned the specific keyword and their total area, khata and plot, whatever was there. So when it was transferred
Which
completely.
is that document
I'll
in
come.
regard to this?
I'll come to that. For clarity, I'll come to the your Lordship may also see the amended written statement of the dattas also, because that would be relevant. Few lines may be repetition, but your Lordship may
No,
kindly.
no problem. Para 11, page 13.
Page 9 में ही it starts. Para 10, page 9, para 10.
Yes. Amended WS.
Your Lordship may also see page 13, para 12 of the fourth column. Last line. Page 13, last line,
Yes.
fourth column. Para 12 of the intervention petition. The defendants of the present suit filed a writ application before the Honorable High Court against the said order dated 10/2/2009 passed by Deputy Commissioner on the ground that the circle officer had jurisdiction to issue M-form and the said writ is still pending. Here, according to me, I may be subject to correction. According to me, probably they are referring to the writ filed by Karm Yogi. Dattas are referring to writ filed by Karm Yogi. They had not separately filed any writ petition. Then, your Lordship may again come back to page 9. On the extreme right, para 10 of the amended WS of defendant number 5 to 10.
Page number?
Page 9. Prior to vesting of zamindari interest under provisions of Bihar Land Reforms Act, none of the predecessor in interest of the plaintiffs were found in possession over the suit land. Therefore, according to the provisions of Bihar Land Reforms Act, they could not have got rent assessed in their names under the provisions of this act. On the contrary, the suit land were being possessed by the predecessor in interest of the answering defendant, then therefore they have rightly filed their returns along with Form K, showing that the lands in their khas possession. And then may I skip or read? Last 2 lines here, 3 lines of the same. All the rent assessment cases referred to by the plaintiff in their plaint are illegal, void, and against the provisions of law. Over and above, the rent has been assessed in the names of the plaintiffs and their predecessor in interest in rent assessment case number 387 so and so, so and so. All these are cases. And in so and so, in such land it cannot be khas possession of the intermediary rent. Now here, subsequent line is against me. In this rent assessment case has been fixed, rent has been fixed for road, nala, ghair majarwa aam, jora, etc., which cannot be khas possession of ex-landlord. Therefore, the revenue officer has rightly cancelled the rent assessment case and thereby rightly cancelled the subsequent jamabandi created in the names of the plaintiff and their predecessor in interest sometime in the year 1982. Which the collector under the Land Acquisition Act was constrained as to who was in possession prior to vesting of Jamindari in the rent assessment case number 1 of so and so, 81, 82 and so and so. Initiated in the instance of the answering defendant and their predecessor in interest. The revenue officer under acting as revenue officer under the collector under the BLR Act has rightly assessed the rent in the name of answering so and so in the year 1982. Can I skip?
Yes.
Next page, page 13. Or page 12, last 4 lines. The plaintiffs have filed miscellaneous case before the Deputy Commissioner Dhanbad for cancelling the jamabandis created in the names of answering defendant and their predecessor in interest, being miscellaneous case number 5 of 2008, in which the plaintiff have challenged the order of collector under Bihar Land Reforms Act. After 25 years, this proceeding is still pending in the court of Deputy Commissioner Dhanbad. So this is the ultimate exhibit 7, which
That is still pending.
no, that final order was passed. That is exhibit 7, and they have also. I'll refer to that also. One thing we have wrongly stated in para 14, your Lordship may kindly strike that off on the extreme right. Petition, this was my observation which they have noted it here. Petition has not disclosed the applicant so and so. It is relevant to mention here that it was defendant number 3 Karm Yogi Greh Nirman so and so, which had preferred WPC number so and so on 29/5/2009, which has been dismissed and not pressed. So
Let's strike it off.
yes, because this was not in the written statement. This is a statement, my submission portion, which
It is just
the
a
submission has been wrongly reported as their statement.
So I should strike to.
Only strike it off, but that statement is otherwise correct. But it is, yes, it is submission, but it is not in their written statement. But this is otherwise true, that they had challenged this, they had filed a writ petition on 29/5/2009, and ultimately they, Karm Yogi, they withdrew on 29/3/2020.
What else? The learned counsel for the respondent plaintiff, representing the plaintiffs, has summarize the facts relating to plaint, intervention petition and written statements in a tabular chart which is as follows. इस chart को first part को copy करेंगे, ठीक है? The learned counsel has thereafter furnished a comparative chart of statements made in plaint, written statement and of the defendant number 3 and defendant number 5 to 10 and has submitted that what transpires from the pleadings exchanged amongst the parties is that it was alleged by the defendants that the M form which was opened, which was issued in favor of the plaintiffs was arising out of fraud and collusion. And fraud, collusion and misrepresentation. He submits that it was not the case of the defendant that M form was never issued or it was subsequently manufactured. The learned counsel has submitted that M form having been issued in favor of the plaintiffs, and if there was any allegation of fraud and collusion, the same could have been subject matter of appeal before appropriate account. But the issuance of M form
They are not fraud here. Actually. They are not saying in their pleading fraud. They say that
misrepresentation,
yes, connivance and
connivance and misrepresentation, fraud. The learned counsel submits that while the M forms were issued in favor of the plaintiffs on one hand, petition was filed on behalf of Dattas under section 5, 6 and 7 of Bihar Land Reforms Act before the circle officer, which was registered as rent assessment case number 1 within bracket Roman 3 of 8182 and 2 of Roman 3 of 8182, and in those proceedings without impleading the Pauls as party, the rent was assessed in their favor. This order was set aside by the appellate court,
by the
False
deputy
with the
commissioner.
parties also.
set aside by the deputy
By
commissioner.
the deputy commissioner in appeal.
Deputy commissioner in appeal, which was numbered as
5 of 2004, 2005, then it was renumbered as 5 of 2008.
5 of 2000 in miscellaneous case number 5 of 2004-05 and was renumbered as
Miscellaneous case number
miscellaneous case number
5 of 2008.
5 of 2008.
False with parties lordship in proceeding, that proceeding also. In 81 that I just wanted to know.
No, we were not aware about it. That was the whole statement. It is my submission that
That is there,
You can show that.
that is an order.
The learned counsel has also submitted that the order passed by the deputy commissioner in miscellaneous case number 8 of 2005,
5 of 2008.
5 of 2004, 5 corresponding case number 5 of 2008
8.
was challenged
Yes.
in a writ petition by the defendant number 3 being WPC number 2586 of 2009, which was dismissed as not pressed on 29/5/2003. Twenty-nine five
2023.
29/3/23. इसका डेट होगा 29/3/23. The learned counsel has submitted that the order of the Deputy Commissioner passed in miscellaneous case number 5 of 2005 corresponding to 5 of 2008 have also attained finality. और कुछ?
Your Lordship, it was argued that we, at the fag end of the trial, we got certain documents exhibited and the trial was vitiated and all those arguments was made. So I'll come to that. Why? First, Your Lordship, the order by on 24/5/2010,
Yes.
we had filed certain documents and they were marked as exhibit number 6, 7 and 8/8/9. This was with objection.
Exhibit
Number 6, 7, 8/8/9.
These were marked with objection.
Yes.
All these documents.
Yeah, these documents. Yes.
Objection. Okay.
Yes. May I describe what is the document?
Yes. So what do you want to say?
Yes.
First you complete your submission and then we'll see.
Yes. So my submission is that the ground which they are taking of delayed filing and marking of exhibit, it is not true, and they were given full opportunity to controvert it. It shall appear from 2-3 facts with order sheets which are placed. Nature of document is very important. Why it was produced?
Okay.
Exhibit 6 is the land acquisition case. Some properties of the balls was acquired by the PCC. So now what happened? The matter ultimately reached the upon reference it reached the subordinate judge. So the two factions were some persons claiming through the sale deeds executed by Dattas, they were claiming compensation, and we were objecting. We were saying that we were entitled to compensation. In that proceeding, land acquisition judge, their 3 M-forms were originally filed, and this was simultaneously being conducted along with this case also. So their 3 M-forms were filed. M-forms were certified copy of those M-forms were taken out and filed in this particular case. In our case, this was filed, and based on the original M-forms, compensation was paid to the Pauls and not to the transferees of Dattas. Reference was answered in favor of Pauls. So that judgment we took out and filed it in this particular case. This is Exhibit 6. Exhibit 7 is that same order which the Deputy Commissioner has passed in miscellaneous case number 5 of 2008. Exhibit 8 and 8/1 is Khewat.
Eight and
8 by 1. And 8 by 2 to 8 by
Hayward is
9.
undisputed.
Huh?
That is an undisputed document.
Undisputed, it cannot be. Therefore, all these documents are public documents. All these.
Hayward, all right. Then exhibit 9.
Exhibit 8 to 8 by 9. Certified copies of continuous khatiyan with respect to the land.
Certified copy of
Khatiyan.
continuous
Khatiyan, yes. This date is important here. This has happened on 24/5/2010, and we closed our evidence thereafter. We closed our evidence on 25/5/2010. No objection whatsoever. So thereafter their evidence started. Their evidence starts on 15/6/2010 and onwards then. They also filed several documents, and their documents were marked exhibit during their evidence when it was going on. Defendant number 3, examination started on 15/6/2010. It closed on 1/11/2010. And then defendant number 5 to 10, they closed their evidence on 24/2/2011. Then on 15/6/2011, defendant number 3 files petition for marking certain documents which were kept in safe custody, on the ground that all these were public documents.
They were marked.
They were marked. Again on, now argument starts. The argument starts on 28/6/2011. Then they filed several petitions, I am not referring to them. Then on 23/8/2011, we filed certain translated copies of the same exhibited document, and defendant number 5 to 10, they file a list along with the document. On request of defendant number 5 to 10, certified copy of return number 390 of so and so marked as exhibit E with objection. So they again file certain document, and that is marked with objection. So it is not we are the only ones who are responsible. Now, why I am coming to the last and most important date, that is on 12/9/2011.
Yes.
Certain documents of defendant was marked with objection, and certain of our document that was exhibit 9 series and 10 series, those were marked but without objection. This is very important. And these are the M forms. Exhibit 9 series is the order sheet of compensation case number 565 of
M forms are exhibit 9 series.
10 series.
Exhibit
10 to 10 by C. Whereas 9 series is the same order which I was reading in detail we had read. The order passed in compensation being paid to the ex-intermediary.
Exhibit 9 series. Like
That
9
is exhibit 9 series.
CD. Why there is series?
9 series is the order sheet of case number 565 of 1955-56. Order sheet of case number 565 of 1955-56. That was marked as exhibit 9 and 9.
This was the order sheet in connection with which procedure?
With the where your lordship had taken the question of payment of compensation to ex-intermediary was in question, and in that the Dattas had objected. Ultimately, they confined their objection to only 4 kWs, and that was the order sheet which is exhibit 9.
That's all with respect to
Yes.
this. The learned counsel for the respondent plaintiff, while answering the objection raised by the appellant with regard to marking of documents at fag end of the trial, has submitted that on 24/5/2010, certain documents were filed on behalf of the plaintiff which were marked exhibit with objection, and those documents were exhibit 6, 7, 8 to 8/9. He submits that the progress in the trial would show that the defendants had full opportunity to controvert the documents which were marked exhibit. While referring to the nature of documents which were exhibited as exhibit 6, 7 and 8 to 8/9, the learned counsel submits that exhibit 6 was the proceeding of land acquisition of the concerned judge relating to land acquisition proceeding with respect to land acquired by BCCL, and the Dattas were claiming compensation.
Purchasers from them.
The purchasers from Dattas were claiming compensation, but such plea was rejected, and it was held that it was the plaintiffs who were entitled to compensation. He submits that in the said proceedings, the M forms were filed, and the judgment was passed taking into consideration the M form filed in the said proceedings. He submits that it was a certified copy of those M forms which were filed in the proceeding covered by Exhibit 6, which was filed in the present case. The learned counsel submits that the claim of Dattas was and their successor in interest was rejected by making reliance on M form, which was filed on behalf of the Pauls.
Yes.
Exhibit 7 is the order of the Deputy Commissioner in miscellaneous case number 5 of 2004-5, equivalent to miscellaneous case number 5 of 2008. And Exhibit 8 and 8.1 are the Khewats, and Exhibit 8/2 to 8/9 are the certified copy of the continuous Khatiyan with respect to the property involved in the case. And these documents were public documents. The Learned Counsel submits that evidence of the plaintiff was closed on 25/5/2010, and the evidence of the defendant commenced on and from 15/6/2010. The defendants also filed certain documents which were marked exhibit. The defendant number 3, the evidence of defendant number 3 was commenced on 15/6/2010 and closed on 1/10/2011, and the evidence of defendant number 5 to 10 was closed on 24/2/2011. He submits that on 15/6/2011, the defendant number 3 had filed certain documents which were marked as exhibit and was kept in safe custody by stating that those documents were public documents. The Learned Counsel further submits that on 28/6/2011, the argument of the parties commenced, and on 23 and earlier on 23/8/2011, translated copy of certain documents were also filed. The Learned Counsel has submitted that on 12/9/2011, certain documents were filed by the defendants, which was marked with objection. And so far as the plaintiff is concerned, they also filed Exhibit 10 series, within bracket Exhibit 10 to 10/2, which were the M forms, but the M forms were marked without any objection from the side of the defendant. The Learned Counsel submits that on the same day, Exhibit 9 series was also filed, which was certified copy of the order sheet of case number 565 of 1995, 1955-56, which was relating to compensation case, and even this document was marked without any objection.
One factual correction pointed out. Yellow chip be in trial court, 3 M forms we have wrongly mentioned. 3 M forms are Latika Bala Paul, Satnarayan Paul, and Nirmal Paul. Latika Bala, page 10 we have mentioned. Page 10 of the
Learned Counsel has submitted that before the Learned Trial Court,
yes.
the following M forms were filed. Number 1,
Latika, Satnarayan, and
Satnarayan,
Nirmal.
with respect to issued in the name of Latika Bala Paul, dash inform number 388 of 6263 semicolon inform issued to Satyanarayan Paul being inform number 389 of 6263 and inform issued to Nirmal Kumar Paul which is corresponding to inform number 390 of 6263 and the inform issued in the name of Ambika Bala Paul by inform number 387 of 6263 and inform issued in the name of Ravindra Kumar Paul being inform number 391 of 6263 has been produced before this court by way of additional evidence through interlocutory application. The Learned Counsel has also submitted that one inform was wrongly produced before the Learned Trial Court, which was relating to inform issued in the name of Haribol Paul, bearing inform number 394 of 6263. The same has no relevance in this case.
Here, Your Lordship, instead of
As Haribol Paul and his successor in interest are not party to the present proceedings.
and their properties are not involved.
And their properties are not involved in the present
instant.
proceedings.
Instead of M form number, Your Lordship may mention M form in rent fixation case. We have wrongly mentioned this.
Inform in rent
Rent
fixation
fixation.
case number 387 of 6263 ऐसे लिखा, ठीक है?
One more thing, Your Lordship, all the three parties, whatever exhibits are there, all the three parties we have produced the same order passed by Deputy Commissioner as they have produced as exhibit B by 3 and one is same document is there.
B by 3 is corresponding.
By dependent number 5 to 10 and
B by 3 is corresponding to your exhibit.
7. With same order passed by
So it is an
Deputy-
admitted document.
Yes, yes,
What
absolutely.
else? एक भी और भी कुछ है?
Exhibit 7 is वही order dated, order passed in miscellaneous 5 2008 and then corresponding there exhibit 5 by 5 to 10 is exhibit B by 3 and then by dependent number 3 appellant their exhibit is exhibit E,
Same document.
same document.
The Learned Counsel submits that there is one document on record which has been relied upon by all the contesting parties. Defendant number 5 to 10 had produced exhibit B by 3, which is the order of the Deputy Commissioner relating to miscellaneous case number 5 of 2008 is equivalent to exhibit 7, which was produced by the plaintiff, and exhibit
B by 3.
B by 3 तो 5 to 10 का है
हाँ,
और exhibit
अच्छा इनका है
and
exhibit E.
exhibit E, which was produced by defendant number 3.
The petition for that exhibit B by 3, also exhibit B is the part of order that is passed in favors. So B and B by 3 on our
उसमें जो 5 to 10 का है ना B and B to B by 3 और B and
B and B by 3.
B and B by 3.
Those who are 81, 82.
ठीक है ये Now, if you would see that order itself are passed by Deputy Commissioner. That actually clarifies the entire thing. Therefore, I am placing that. Exhibit 7.
We were reading from Exhibit 7 earlier.
हाँ,
Exhibit 7 से ही शायद हम लोग
हाँ, 7.
How much more time will it take?
Some time. Your Lordship may continue tomorrow with that.
कल proceed हो जाए?
Yes.
और आपको क्या बहस करना है? Exhibit
थोड़ा है, थोड़ा धीरे.
हाँ, that's your Lordship. Patience are there.
नहीं मतलब I just want to place few exhibits. Those are very relevant there for place of. So otherwise.
कल जो भी आप एग्जिबिट प्लेस करना चाहते हैं ना उसका एक लिस्ट दे देंगे
अच्छा,
ये एग्जिबिट आप रेफर करना चाहते हैं
ठीक,
सो दैट आपको लिखाने में
ठीक, ठीक,
एंड देन वी विल रेफर टू दोस डॉक्यूमेंट्स एंड
ठीक.
देन यू विल हैव टू रिस्पोंड
Yes.
हु विल रिस्पोंड और कौन बचा इनके अलावा
We'll also.
हां यू विल आल्सो रिस्पोंड और इनके अलावा कौन बचा
Once they respond, because the actual dispute is between them.
हाँ.
We are
So
permitted to
you are purchases from
for.
There are two sets here. Mr. Ayush Aditya, he had filed a specific performance that was decreed. Then that is going on. That is a separate issue. But he's essentially he's sailing on my boat.
He is a party in this proceeding.
Yes, here he is Bhavesh. He was made a party, and then another set is Bhavesh Komotrate, who is also claiming through me, who claims the property on the basis of sale deed executed by my power of attorney, which I have disputed and I have filed a separate suit. That would be a separate matter. So here,
So their locus you are disputing.
I'll be disputing.
The power of
attorney holder is the
so far as
same
my
person.
locus is concerned, he is not disputing. because
So far as your locus is concerned, he is not
He is not.
disputing. So you are sailing on the same boat.
Same boat,
But so far the locus of another dependent
Bhavesh.
number.
Yes.
They
This
depend
should
upon
not
my-
come, but then again I will have to bring something else.
So they may
Just a
bring-
second, just a second. No, you just
I'm
made a
just
comment.
placing the entire
Let me give an answer. So he is the same power of attorney holder who conducted the suit. He is the same power of attorney holder who won the suit. He is the same power of attorney holder after winning the suit, transferred by way of registered CD to us. My contention is that so far as we are concerned, we derive the right from board. So nothing of this sort should not come. These comments, we are just.
That saying it is not under challenge.
Once
by
he
you.
says
So,
this, he is
I'm
the
just-
same power of attorney
I'm-
holder who withdrew the original M form from the land acquisition cases and he has kept it. If he is representing him, then he wants,
we will
he
then
takes, he
Because
takes
my-
up
my-
the document and does
So
not
may I
return it.
clarify, not this dispute at present should not
Because
be-
Must not
So
defend
you
the
should
power
not,
of
no,
attorney.
no, I will. As a salary, I'm defending power of attorney holder. So I'm saying. So he should not make a comment.
So there is a separate suit pending between
Pending,
both
I
of
have
you.
challenged the
there are-
sale deed executed by my power of
That is
attorney holder.
pending.
So I'm
absolutely.
saying.
So suppose your power of attorney is held to be valid, his power is held to be valid, then under such circumstances the suit will
Sale
be
is
taken.
valid.
The sale would be valid.
That is what they have said. That is what they have said. That is what they have said. So
So you
whatever
should be
I have
happy about
done, they save us. They say, okay, what you have done.
But unless Paul wins here, the appeal is dismissed.
That
Then
is why
only
I'm
we
saying
come
don't
into the
enter.
picture.
That is why I'm saying don't enter. Don't bring all these disputes here.
No, definitely.
That is
There
why
is a judicial order to that effect.
if you are trying to help, so then
I'm
have
not
to
trying to help.
I'll
I'm just trying to-
I'll enter as a power of attorney.
Definitely not
he
so.
must
Have
enter.
that.
So I'm saying, so far as the suit was between Paul and Dattas, so that what is that? And
You were
comments.
defendant number. When did you enter into picture?
I filed the
Using
suit.
appeal, not using appeal.
We filed the suit.
In the appeal.
As a power
It
of
is the
attorney
power of
holder, he
attorney.
filed the suit.
Tarun Gandhi Ghoshal filed the suit.
How can he represent? He is not even a party here. He
Are
is
you
a
a party
citizen.
here?
To whom he is representing? and
Whom
to
are
that
you
is-
representing? Defendant number बताइए किसको represent कर?
I'm here. I'm defending Bhavesh.
You
Bhavesh
are-
is a party. Yes, he is a party.
Who is the
We are the
party?
subsequent purchase. We are the subsequent purchase.
Just a moment. Who
Yes.
are you representing? Respondent number?
He is respondent number
19.
19.
But he is 19, I am 16, 17.
19, 16, 17, 18, right?
Yes.
And this 19, 16, 17, 18 were parties in the suit also.
No.
In appeal.
They
In
have-
appeal,
In
never
appeal, we
made.
have been included.
In appeal, you have been
They
included
made
as
part,
well.
yes. So my simple prayer is that whatever is the order is the order. So far as we are concerned, there's
By which
no
order you were
comments.
made party? By which order you were made party?
No, the order was passed by the High Court in Central.
बताइए, आप अपना जेनेसिस तो बताइए,
हम
आपका जन्म
हमारा-
कहाँ से कब हुआ?
हम दे दें, हम वो सब दे देंगे. हमारा सिर्फ इतना कहना है कि there are suit pending in the court.
Maybe pending.
But if your lordship intends to, if they try to bring in
What
this
will I
aspect,
intend? I do not know. I will
But
intend
if-
only what is there on record.
See,
So
if
beyond
they-
तो हम नहीं. I will not intend anything more. I will only decide the case. ये डीट थोड़ी है.
so that is what I am saying.
I will
The
decide the
subsequent
case on the basis of.
subsequent purchasers, any comment upon subsequent purchaser, I will just say that if
You
that
must have intervened in the matter.
yes we
You have
intervened.
invited your comments, isn't it? 14, 12, 18.
Then let them comment, but then we'll have a full
Just
fledged.
a moment.
We'll also give our full fledged argument.
Fourteen, 12, 18 through into the Petri application, right? You see, in view of the ratio laid down by the Honorable Apex Court, the petitioner, being the transferee pedantillite, are included as respondent in the present appeal,
My lords.
subject to the rider,
Yes,
that the applicant will be entitled to pursue such defense as were available to the original owners,
original owners. Yes,
and such title shall remain subservient to the rights of the plaintiff in this matter.
that is
तो
what
आप इनके बियॉन्ड तो कुछ बोल नहीं
हम चाह भी
पाएंगे
नहीं रहे.
और
लेकिन
आप
ये
लोग का आपस का डिस्प्यूट यहाँ पे डिसाइड नहीं हो सकता।
बस हम इतने ही चाह बस.
अरे हम भी नहीं बोल रहे हैं.
हमने बोला.
लेकिन
आपने
बोला क्या अभी?
आपने explain
हम-
करने की
हम
कोशिश
ये नहीं
किया.
बताएंगे. I have
इसका
to-
जरूरत को occasion नहीं था.
I
There was no
have to
occasion.
say, I have to
There was
say,
no occasion.
I have to disclose that what I have, this is interstate dispute between us,
You see,
where I have filed the suit, so there was no occasion.
there could be numerous dispute between both of you, but he can only argue the case by standing on your foot.
Absolutely,
Definitely,
Nothing more.
absolutely.
क्योंकि इनका कोई अलग से रिटन
अलग से कहाँ
स्टेटमेंट
से हो?
जब इनका कोई अलग से रिटन स्टेटमेंट नहीं है या कुछ भी इनका अलग से कोई प्लीडिंग नहीं है, ना ही कोई ऑर्डर था कि दैट ही विल फाइल अ सेपरेट प्लीडिंग, देयरफॉर ना ही कोई इनका एविडेंस है, इनका तो कुछ नहीं है. इनका वही है कि भाई जैसे अगर आप तर गए तो ये भी तर गए.
Rightly or wrongly,
Yes.
Lordship, they have to
उसके
assist
बाद
themselves.
आप लोग का आपस में डिस्प्यूट इज
वो
सब्जेक्ट
वो
मैटर
चल
ऑफ
रहा है.
अनदर
वो
लिटिगेशन.
That is what I was disclosing, that we have a separate suit which is there, but ultimately they are
That will
claiming
be
through.
decided, that's-
They are
But
claiming
mix it.
through you, whatever be your
Yes.
dispute, as in that is subject
Yes,
matter of
yes,
another
yes.
litigation.
It may happen someone has impersonated them and they have sold the
वो
land.
सब
Yes,
कहानी
it's
चलते
separate
रहेगा,
thing,
क्रिमिनल
हाँ.
सिविल केस तो अभी
Yes,
चलेगा,
अब
खत्म
बहुत
ना
चलेगा.
होगा.
All civil lawyers will be.
बस
बस इतना ही चाहते हैं कि आप लोग को कोई पॉइंट छूटे नहीं,
Right.
बस
कि फिर से रिमांड हो गया सब.
We are obliged.
ऐसा कहानी मत
ये
करिएगा.
अब नहीं होगा. That was
If anything is
for different-
missing, Lordship, we will also point out. Just want to assess the court properly so that the
Pose this case for further hearing. I think
Demand was due to state was
आप लोग
included
अपना
at
कुछ
that
बनाए
place.
हैं नोट्स कि ऐसे ही खाली सुन रहे हैं?
पूरा नोट्स कोई बता रहा है, इसके जवाब देंगे, अच्छे से बना के देंगे।
जब आप जवाब देंगे तब हम आपके नोट्स के साथ जवाब देंगे,
हाँ,
क्योंकि देन यू विल हैव टू प्लेस योर नोट्स.
नोट्स के साथ ही हम बहस करेंगे,
हाँ, आप नोट्स के साथ
नोट्स और
करेंगे.
जजमेंट के साथ ही हम करेंगे, क्योंकि नाउ इट इज माय काउंटर आर्गुमेंट।
ठीक है ना? अपने नोट्स तैयार नहीं होगा तब तक आपका बहस हम नहीं सुनेंगे. आप भी सुन लीजिए. आपका नोट्स नहीं तैयार होगा तो बस फिर ऐसे ही, मतलब जब फ्री स्टाइल में होगा तो फ्री स्टाइल में आपका सबमिशंस भी होगा. फ्री स्टाइल बहस करिएगा तो वैसा ही फ्री स्टाइल जजमेंट मिलेगा. राइट? जैसा फ्री स्टाइल काम करिएगा वैसा ही. कंप्यूटर में गलत फीड करिएगा तो गलत ही निकलेगा, और वेग फीड करिएगा तो वेग ही निकलेगा. वेग क्वेश्चन कैन हैव वेग रिप्लाई.
अब हुजूर एआई का जमाना है, जैसा एआई वो डालेंगे।
चलो, इसका जरूरत है, इसको अच्छा, ठीक है. ये इनको जरा दे देंगे ना, ये कॉपी आप दिए हैं.
हाँ,
एडिशनल रिटन स्टेटमेंट और क्या है इसमें, जरा चेक कर लीजिए आपके रिकॉर्ड के अनुसार मैचिंग है कि नहीं. एक उनको दे दीजिए भाई, कंटेस्टिंग प्लेंटिफ को दे दीजिए. सबसे ज्यादा लड़ाई तो उन्हीं के साथ करते हैं.
From daily list for judgment item 1 second up to 309 of 2016.
The substantial question of law is answered in favor of the appellants and against the respondents, and consequently the suit for declaration of right, title and interest of the plaintiffs over the suit property and seeking recovery of possession from the defendants is dismissed. This appeal is allowed.
Orders from supplementary list item 1 second up to 282 of 2019.
In this case, I am appearing on behalf of the appellant. Namloda, I got the information that the appellant died, so I have to take step for substitution.
Essay number 282 of 2019. Learned counsel for the appellant,
Sole
Mr.
appellant.
A.K. Sani, submits that the sole appellant has expired. कब टाइम चाहिए आपको? पोस्ट ऑन 12th of August. 12th August तक क्या ही होगा, कर लेंगे भाई.
12th August दे देंगे.
Item 2 second appeal 354 of 2019.
Your Ladyship and Advocate, second appeal, there are two IAs. One is for substitution of the sole respondent, and the second IA, Your Ladyship, is for stay of the execution proceedings
Substitution,
of the sole respondent.
which is that idea.
IA number 5885 of 2025.
Sole respondent has expired.
Yes.
The execution में क्या ही हो रहा होगा? कुछ नहीं हो रहा होगा.
Your Ladyship, two things.
Execution में तो कुछ नहीं
उनके
हो रहा
लीगल
होगा.
रिप्रेजेंटेटिव्स एग्जीक्यूशन केस में हैं. इनको नोटिस मिला 11/4/2025 का एग्जीक्यूशन प्रोसीडिंग्स का thereafter he appeared, and after appearing from the records of the execution case he got to know about the death of the sole respondent. Thereafter the substitution petition and took developments in the execution case, Your Ladyship. In the IA file for stay, that is at annexure 3 page number 20, it is apparent that in execution case the office has been directed to issue writ to Nazir Civil Court to submit Nazir report, and the next date is 13th July.
13th of?
13th of July, Your Ladyship.
In execution?
In execution case.
They have been substituted.
Yes, yes. And from the records of the execution case only we got to know about the death of the sole respondent.
Where have you said that in the execution case he has been substituted?
Your Ladyship, from the records of the execution case, if Your Ladyship may kindly have.
I don't know.
Paragraph 7 of the IA number 5885. We have stated that from the records of the execution case,
Where have you stated that they have been substituted?
if Your Ladyship sees the annexure 3 in the IA number 55532, it is apparent that the name of the legal representatives of the deceased respondent is appearing in the execution case. Annexure 3, page number 15 of
आप अपने पिटीशन में कुछ मत बोलिए, बस हम लोग एक कनेक्शन से दूसरे कनेक्शन में ढूंढते रहेंगे. Annexure?
Your Ladyship,
Page
IA
number?
Annexure 3, page number 15. In the IA
15?
number, yes, IA number 553. The order sheet of the execution case. From the first page, it appears that their name is not.
What does it appear?
Your Ladyship, the name of the legal representatives of the deceased respondent. Your Ladyship, I have page 15.
Nini Gupta.
Mini Gupta, Rachit Kanle, and Gunit Khan.
IA number 5885 of 2025. Also for the appellant, I submitted that. The petition has been filed seeking substitution of sole respondent. Other side is not appearing.
No, Your Ladyship.
Notice has been
A
served.
notice has been served in the service report. It is mentioned that he has died on 8 June 2022. Thereafter, nobody has asked.
Of the sole respondent, he submits that the appellant came to know from the execution proceedings about the death of the sole respondent in the Ajit Kumar Gupta. The details of the legal heirs and successors have also been known through the execution proceedings. The details have been mentioned in paragraph 8 of the interrogatory application. The learned counsel has submitted that in the execution proceedings, the writ for delivery of possession has been issued.
No, Your Lordship, not for delivery of possession.
The execution case is proceeding and an interlocutory application being IA number 5532 of 2025 has been filed for stay of the execution proceedings. Let notice be issued to the proposed legal heirs and successors of the sole respondent in IA number 5885 of 2025, whose details have been mentioned in paragraph 8 of the interlocutory application, for which requisite under ordinary process be filed before this court within a period of 1 week. In addition, it will be open, the petitioner is directed to serve notice upon the proposed legal heirs and successors of the sole respondent through the advocate who is conducting the case on behalf of the legal heirs and successors of the sole respondent in the court, and file an affidavit of service of notice. Since the appeal, the second appeal has been admitted, white order dated
28/11/2024.
28/11/2022,
24.
sorry, 28/11/2024. The notice to the proposed legal heir and successor should accompany a copy of the memo
The leadership may also kindly pray for stay until appearance because the learned executing court is proceeding.
Nothing आप तो बता ही नहीं रहे. Wait for delivery of possession
The
issue हुआ
leadership
कि
at page 20 it is mentioned that office has been directed to issue writ to Nazir Civil Court to submit Nazir report, and the next date is 13 July. And the leadership of the delivery of possession is taken, the second appeal would effectively become infructuous. Since he is in possession of the
no delivery of possession अभी तक issue नहीं हुआ, उसको पहले कर देंगे आप कभी. You just file it. You just file it, right? At this, the learned counsel for the appellant has shown urgency in the matter, as the executing court is proceeding. Execution में भी आपको stay में भी कर दीजिएगा notice, stay of execution में. ठीक है, आप सब चीज़ फाइल कर दीजिएगा. Memo of appeal, the IEA for execution जो stay है, and then substitution petition. It will be open to the सब में notice कर दीजिए, and post this case on, बताइए कब कर दें.
leadership is shown
तारीख कितना है? Today is 8. कब है next date?
next date is 13th July.
Post on 29 July. Ordinary process फिर हटा देते हैं क्योंकि सर्विस रिपोर्ट नहीं आ पाएगा. We take only 10 दिन. ठीक है? The notice should be served through the advocate representing the proposed legal heirs and successors in the executing court in presence of witnesses. An affidavit of service of notice in the aforesaid manner should be filed before this court latest by 25th of July. नहीं फाइल करिएगा, अगला डेट में केस टेकअप नहीं करेंगे. 28 को फाइल करिएगा, हम केस टेकअप नहीं करेंगे. I'm telling you.
We will find
25 तारीख तक फाइल करेंगे. और ऑर्डिनरी नोटिस हटा दीजिएगा, ठीक है? रिकॉर्ड आ गया इसका?
नहीं.
रिकॉर्ड नहीं आया मतलब क्यों नहीं आएगा?
records have been called for leadership on the same day, 28/11/2024.
रिकॉर्ड कॉल फॉर व्हाट?
The matter was admitted and the LCR was called.
In spite of order passed by this court, the records from the concerned court has not been received.
Offer हुआ है लेकिन
Office is directed to issue express reminder. such that the matter is taken up on the next date.
till the next date I initiate the inquiry.
हो जाएगा इतना काफी। उस दिन अगर नहीं जाइएगा तो आई जस्ट डू नॉट